members of the Academy, distinguished guests, ladies and gentlemen, you are welcome to today's program. Shall we all be upstanding as we welcome the chair and the speaker? And while they walk in, please put your phones on vibrate.
President of the Danquah Sciences, past presidents, vice presidents, fellows of the Academy, justices of the Superior Courts, members of the Ghana Bar Association, Your Excellencies, distinguished guests, students, ladies and gentlemen. On behalf of fellows of the Ghana Academy of Arts and Sciences, Ghana's premier learned society, I warmly welcome you all to day 2 of a 3-day event in memory of a foundation member of the Academy, Dr. J.B. Danquah. Dr. Danquah died in prison in February 1965, fighting for freedom in all its manifestations. The event consists of a series of 3 lectures delivered on varying themes ranging from law to philosophy, literature, medicine, health, religion, and nation building. Incidentally, the maiden lecture was delivered in 1968 by His Excellency W.V. Van Leer, also a founding member of the Academy, who at the time was Ghana's High Commissioner to Canada and had had a long and distinguished career at the bench. The theme for his presentation was the law, human rights, and the judiciary. You may download a copy from our website at www.gaas-gh.com. This event is being streamed live on the Academy's Zoom, YouTube, and Facebook platforms. The Danquah Institute is also streaming proceedings on its social media pages. Thanks to the combined efforts of the Danquah Institute, Owusu Dapa Law and Associates, and S.K. Boafo and Company Law Chambers of the Ghana Bar Association President, we are also transmitting live on Star 103.5 FM. This year, we have been generously supported by the following sponsors: Goyle Company Limited, the Danquah Institute, S.K. Boafo and Company, Owusu Dapa Law and Associates, Mr. Augustine Frimpong, G.I. PC, Lemont Food Limited, and Africa Digital Rights Hub, which graciously offered to provide packed refreshments for our guests. Please give these supporters a resounding round of applause. Thank you. Now the chairperson for tonight's event is Emerita Professor Isabella Kwachi, Vice President of the Sciences Section of this Academy, a member of Council. She is a professor of immunology and parasitology at the University of Ghana. She's also a fellow of the African Academy of Sciences. The first emerita professor in the sciences at the University of Ghana, she established the immunology unit of the Noguchi Memorial Institute for Medical Research in 1980. From 1980 to 1983. She was the first female director of the UG School of Public Health and the foundation dean of the School of Public Health, also making her the first female dean in the College of Health Sciences at the University of Ghana from 2002 to 2007. She is a former UNESCO chair for Women in Science and Technology in the West Africa region. She won the 2014 Laureate African Union Kwame Nkrumah Award for Women in Science. She is the 2019 laureate for the Ghana Southmide Ladlow Award by the American Society of Tropical Medicine and Hygiene. Women's World Day 2021 recognized Emerita Professor Kwachi as one of 7 women in science who have changed our world for the better. Ladies and gentlemen, please welcome our chairperson, Professor Isabella Kwachi.
Thank you, Honorary Secretary, for your, Professor Elenita, for your kind words. President of the Academy, past presidents of the Academy, Vice President of the Arts Section of the Academy, Fellows of the Academy, Justices of the Supreme Courts, members of the Ghana Bar Association, Your Excellencies, distinguished guests, students, ladies and gentlemen, I am honored to serve as the chair on day 2 of a 3-day lecture marking the 55th in the series of the J.B. Danquah lectures. The speaker for this series is Professor Richard Frimpong Opong, Fellow of the Ghana Academy of Arts and Sciences since 2016. He is a professor of law at California Western School of Law in San Diego, USA. He is a member of the Royal Society of Canada's College of New Scholars, Artists, and Scientists, and an associate member of the International Academy of Comparative Law. He is called to the Ghana Bar. Professor Opong has taught and worked for academic institutions in the United States of America, United Kingdom, Canada, the Netherlands, Saudi Arabia, Ghana, South Africa, Tanzania, Malawi, and Uganda. In addition, he maintains teaching and research interests in a broad range of commercial and business law subjects, such as the law of contracts, international commercial contracts, international arbitration, international trade and investment law, international business and economic transactions, sale of goods laws, and conflict of laws. Professor Pong has published 8 books and over 55 articles, book chapters, and book reviews. Some of his writings have won international prizes, and he's frequently cited in academic publications and has been cited in judicial decisions. Professor Pong was a member of the working group of the Hague Conference on Private International Law that developed and drafted the Hague Principles on Choice of Law in International Commercial Contracts. That was in 2015. And in 2012, he held the Director of Studies, Private International Law, the position at the Hague Academy of International Law. Law firms frequently consult him on significant transactions. In addition, he has acted as an arbitrator, counsel of consultant in major international and domestic arbitrations before the ICC Court of Arbitration, the London Court of International Arbitration, Permanent Court of Arbitration, Arbitration Institute of the Stockholm Chamber of Commerce, the Singapore International Arbitration Center, and the Ghana Arbitration Center. On the academics, Professor Pong completed his PhD at the University of British Columbia and his postdoctoral studies at the Schulich School of Law, Dalhousie University in Canada. In addition, he holds a Master of Laws degree from Harvard Law School, a first-class Master of Laws degree in commercial law from the University of Cambridge, and a first-class Bachelor of Laws degree from the University of Ghana. Ladies and gentlemen, a round of applause for our speaker, please. Thank you.
Madam Chairperson, President and Fellows of the Academy, ladies and gentlemen, before I proceed to the substance of today's lecture, let me pay tribute to those Fellows of the Academy who use their J.B. Danquah Memorial Lectures to address education in Ghana. They are Professors R.K.A. Gardner, Professor Kwapon, Achampong, Ivan Adai-Mensah, Marian Adi, and Professor Kwesi Yanka. Today, I tread the same path as these illustrious fellows. However, I do so with a different lodestar in mind, namely legal education. My appointed topic for today is legal education and professional competence in our digital world. There is a myriad of challenges facing legal education in Ghana. In recent times, the most topical has been admission to the Ghana School of Law and the interventions of Parliament in this admission process. Moreover, a 2019 joint report by the General Legal Council and the National Accreditation Board identified other challenges. These include understaffing, high teaching load, high staff-student ratios, inadequately stocked libraries, lack of effective mentorship for newer institutions, low remuneration for lecturers, lecturers using working hours to engage in private practice, and poor publication record of lecturers. Scholars have also noted other challenges. For example, in a recent book chapter honoring Mr. B.J. Darocha, one of the finest legal minds Ghana has ever produced, Mr. G.A. Sapon noted an epic drop in the standards of students entering the Ghana School of Law. In addition to these challenges, many aspects of the contemporary 21st century context demand a rethink of legal education in Ghana. These contexts include internationalization, increasing emphasis on interdisciplinarity, and growing concerns about access to justice, the subject matter of yesterday's lecture. To Today's lecture focuses on one such context, digitalization, especially the training of law students to work in the digital era and the impact of digitalization on law and legal practice. This lecture therefore addresses the skills, the knowledge and competencies that law schools must provide to students in order to enable them to practice or work in a world that is increasingly marked by digitalization. In addition, the lecture explores the potential of digital technology to transform the delivery of legal education in Ghana. Thus, in this lecture, I argue that legal education in Ghana should be reconceptualized to integrate practice and other forms of legal work in the digital world. It is no longer enough to train students to, as is often asserted, think like a lawyer, even if one ignores the apparent ambiguity in this refrain. The need for us to reconceptualize legal education is relevant, regardless of whether students graduate to practice law or choose to work in other aspects of the Ghanaian socio-economic and political environment, or indeed anywhere in this increasingly globalized world. Essentially, this lecture is premised on the view that at present, legal education in Ghana fails to equip graduates with the necessary skills to practice in a digitally mediated world. However, studying and understanding the law without appreciating the digital context will result in a purely historical viewpoint, thereby making students ill-equipped for contemporary and future applications of the law. Such study and understanding of the law are unacceptable given the increasing digitalization of legal practice, Ghana's current judicial system, and the nation's broader quest to become a digitalized economy. Any reflection on legal education necessarily entails an engagement with legal practice, the provision of legal services, and the law itself. In reflecting on legal education, I think it is simultaneously important to consider the functions and needs of the legal profession. Indeed, it is legitimate to expect that law schools would keep pace with the demands of legal practice, actively preparing students for practice and other careers. Law schools in Ghana have always been required to carefully balance their academic mission, which is the teaching of the theoretical and foundational aspects of the law, along with their mission to the bar. Consequently, legal education institutions in Ghana have taught the practical skills that are relevant to legal practice. The way in which these institutions respond to the evolving impact of the digital world on the law and life itself in Ghana will significantly determine the future of our legal practice. Ghana's law schools definitely occupy a strategic position in our society as producers and distributors of legal knowledge. Despite being a small component of the legal system as a whole, legal education provides a lens through which the future of the legal system and the wider society can be ascertained. Today's lecture is organized as follows. Following this introduction, I will examine the digital context that is shaping law and the study of law, together with the expectations that are subsequently created regarding the competencies that students should have attained on graduation. Next, I will examine the existing state of legal education in Ghana, exposing its inadequacies in terms of providing students with the necessary competence for our digital world. This is followed by a discussion on the various ways in which these competencies can be achieved, as well as an examination of the manner in which we can take advantage of digitalization in our mode of delivering legal education. Finally, I will offer some brief reflections on the proposed legal profession bill, especially the extent to which it supports the need to train students for practice or work in the digitalized world. The digital context. Ghanaian and foreign scholars agree on the impact of digital technologies on the legal profession and legal services industry. However, notwithstanding this happy consensus, there is very little data on the uptake of digital technologies in Ghanaian law firms. This makes it difficult to determine how far digital technologies have permeated the legal services industry in Ghana. Nevertheless, in one 2013 study, Amda Redu Kwapon observed that Ghanaian law firms were gradually embracing technology and that this was exerting a positive impact on legal practice. In addition to this relatively dated study, there is reliable anecdotal evidence of the expansion in technologically mediated legal practice in Ghana. In addition, the Ghana Bar Association has been proactive in organizing training workshops on digital proficiency for its members. This need for ongoing skills update in technological proficiency among members of the bar indicate that it has become an important focal point of the profession. Similarly, in the first lecture, I discussed various initiatives to digitalize our courts and legal processes. In light of these transformations and demands, there is an increasing expectation that law graduates will possess enhanced digital skills which enable them to practice in the digital world. The demands of modern-day legal practice make it imperative that students are competent in using digital technologies and communication methods. In this regard, graduates are expected to be cognizant of the ways in which technology affects the processes of legal practice. This includes knowledge of relevant legal software, online systems, electronic processing of legal documents, and digital technologies that affect the process of litigation. Further to the above, graduates are expected to be aware of and deal with areas where digital technologies have impacted substantive law. This is because digital technologies raise novel issues in many substantive law domains. For example, in the digital world, a student's knowledge of contract law is incomplete without an appreciation of contracting in the digital marketplace, together with the unique challenges it raises in regard to issues such as contract formation, consumer protection, and the enforcement of contractual rights. Likewise, knowledge of the law of defamation is incomplete without a consideration of the unique issues posed by defamation via the internet. Digital platforms likewise raise significant questions affecting intellectual property rights, of which no intellectual property law student can afford to be ignorant. Ghanaian law imposes an obligation on lawyers to offer competent representation. Section 6 of the Legal Professional Conduct and Etiquette Rules 2020 provides, and I quote, "A lawyer shall provide competent representation to a client in the form of legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation," unquote. However, there is no express duty of technological competence for Ghanaian lawyers. Moreover, technological competence, including digital competence, is not one of the prescribed areas of knowledge that are required for admission to the legal profession in Ghana. In essence, the importance of technological competence is yet to be fully reflected in the regulatory framework of the Ghana legal profession. Given this regulatory lacuna, it is unsurprising that law schools in Ghana have largely neglected to make the acquisition of technological competence a key component of their curricula. In fact, the standards governing legal education in Ghana are silent on the topic of legal technology and the law. Nevertheless, I think it would be parochial to think that the sole basis for arguing for students to be trained in digital capabilities consists of developments within the courts and law firms. I think equally relevant are the wider efforts to develop a digitalized economy in Ghana. For example, in the 2022 budget statement, it's noted by the government that is committed to bridging the digital divide and making technology a driver of our socio-economic progress. A more robust digitalization of the Ghanaian economy would create an economic ecosystem fueled by data, with Ghana ushered into a brave new world. The effects of this digitalization would be felt within and outside the economy. For example, I think it would fundamentally alter how we relate to each other, including our hallowed value for interpersonal relationship, a value that often informs whether we take recourse to the law to resolve our problems. It will change the nature of the relationship between consumers and sellers, provide consumers with better opportunities to shop around, engender greater competition for consumers' cities, and lead to calls for better consumer protection in the digital marketplace. What are the implications of such a data-based or data-driven ecosystem for law, legal practice, and adjudication in Ghana? A full exploration of these implications go beyond the scope of this lecture. However, I think it is worth highlighting that a data-based ecosystem raises novel regulatory, intellectual property, data protection, privacy, cybercrime, and jurisdictional issues. To these, I will add consumer protection in the digital marketplace and labor relations on digital labor platforms, the subject matter of my third and final lecture tomorrow. In this regard, it is noteworthy that several academic institutions abroad are already offering courses on law and the digital economy. Similarly, we need to prepare our students for the new digital economy rather than the old economy. Digital competence is imperative for lawyers operating in a digitalized economy. Aside from the above, a discussion of the digital context would be incomplete without mentioning the COVID-19 pandemic and its impact. Amankwa Amwa has described COVID-19 as the great accelerator, fast-tracking the existing global trends towards embracing modern technologies. The pandemic has brought to the fore a need to adjust how we do things and the need for us to be more receptive to technologies as mediators of our interactions. Digital learning has been the response of our law schools to the lockdown that was precipitated by the pandemic. However, at the same time, the response of our law schools exposed how ill-prepared our digital education infrastructure was for the task, assuming it even existed at all. The extent of the transition from an analog to a digital world varies from country to country. In some countries, disruptive technologies are already at play. In these countries, the use of artificial intelligence in legal research, discovery, document processing, and dispute resolution is expanding. Added to these are emerging online service providers such as LegalZoom and Rocket Lawyer. These transitions are challenging lawyers' monopoly over the provision of legal services, a monopoly that is often entrenched by legislation, as is the case in Ghana. Meanwhile, other countries like Ghana are at a very early stage in this transition from an analog to a digitalized world. The available technologies in Ghana are geared more towards allowing lawyers and legal service providers to perform their existing work more efficiently. At present, the predominant technologies in Ghanaian law firms are simple. They merely include email and office applications, accounting and billing software, and domestic legal research databases such as dennislaw.com. Moreover, the courts have lagged behind law firms in embracing new technologies, although, as discussed in yesterday's lecture, the situation is changing significantly. The preceding exposition on the digital context should not be understood as an imperative for all legal education and legal service provision to become digitalized. Much of the work that is performed by lawyers and the skills that are required for their work cannot be digitalized. Thus, this lecture does not subscribe to the death of the legal profession as predicted in some of the scholarship on the impact of digital technology on the legal profession. Accordingly, I think it would be essential that we continue teaching critical and analytical thinking skills, creative problem solving, advocacy, persuasive writing, and the like in Ghana law schools. However, these skills should be taught in recognition of the fact that students will probably work in a variety of legal and non-legal contexts in the future. Similarly, there will still be a need to continue teaching traditional black letter areas of law, such as contract, tort, and property, although the substantive law will necessarily incorporate the impact of digital technologies. I will now turn my attention to the current nature of legal education in Ghana. Legal education in Ghana adopts a paper-based approach to teaching and learning. Traditional education practices such as on-campus face-to-face teaching and closed-book assessment continue to dominate our legal education. In brief, legal education in Ghana has traditionally been teacher-centered. Legal education is therefore mainly offered by integrating a combination of didactic methods through which knowledge is imparted via lectures and dialogue in a tutorial setting. In these settings, the teacher asks students questions and encourages discussion to test their understanding of the subject. The dominant model of law instruction in Ghana is the sage on the stage approach. Under this approach, a lecturer or professor, armed with the mastery of the course materials and the power of speech, dazzles students with magisterial lectures in the classroom. This is often followed by occasionally daunting tutorial classes which students have to endure. As a student, I recall the intimidating presence of Mr. John Kwabena Ezi as he expounded what he called the purposive approach to interpretation in Ghana. I also remember Mr. Jekedakon's abstruse exegesis on hearsay in the law of evidence. Moreover, how could I forget Colonel Christian Hans Kwame Lodo's astonishing grasp of the complexities of Ghanaian law and conveyancing, which was diminished by his most terrifying refrain to all of us: "You will fail, you will fail, you will fail," as he moved through the classroom, terrifying everybody in the class as to our future. The structure and content of legal education in Ghana have remained largely unchanged since the establishment of the Department of Law and the Ghana School of Law in 1958. The only major structural change has been the significant increase in the number of law schools. In Ghana, for the most part, law students are trained for the court and not for careers other than legal practice. A telling indicator of this is that despite the varied tasks performed by lawyers in Ghana, such as negotiating agreements, drafting legislation, resolving disputes, managing institutions, and spearheading legal and social reform, our law schools focus primarily on teaching students how to read and analyze old cases, especially on the LLB programs. The core curriculum of our law schools, as in other common law jurisdictions, is closely tied to areas of knowledge that are ostensibly required for legal practice. The fact that we train students mainly for law firms and the court is the result of a confluence of factors, the first of which is historical. After independence, there was an acute shortage of lawyers and judges, since very few had been trained in England for the country. Consequently, there was an urgent need to train lawyers to run our courts and the various government departments. Second, unlike in other jurisdictions, most of our law students come to study law with one career expectation in mind, which is the practice of law. Very few have no intentions whatsoever of not practicing upon graduation. Moreover, the curriculum of our law schools is directed at preparing students for legal practice, mainly commercial legal practice. As a result, there is very little focus on public interest law. Thus, we can certainly do a better job of exposing law students in Ghana to alternative career paths, including public interest careers. Nevertheless, I have to add that our existing approaches to the provision of legal education has served the country well, served the Ghanaian legal community and society well. This education has produced some of our best lawyers and judges who have excelled in their work in Ghana and abroad. However, I would argue that the environment in which law students currently operate and will operate in the future calls for a rethink of our methods of legal education. Specific to the topic of this lecture, the digital world is significantly shaping contemporary legal practice, and accordingly, the needs of law firms and their clients. Law schools in Ghana cannot remain oblivious or insensitive to this new context. Consequently, law schools should provide a type of training that will enhance students' digital capabilities. This will involve a learning environment that approximates the complexities of the real-world responsibilities which will later be performed by the learners and the future environment within which they will operate. Law schools have a general obligation to prepare law students more effectively now for the practice of law tomorrow. At present, there appears to be a general indifference in our law schools as to the importance of teaching digital competence to students. Our law school curriculum is filled with traditional doctrinal subjects taught using modest technology. Unlike in other countries, where responsive curriculum reform is the staple of many law schools, I am unaware of any significant curriculum reform in a Ghanaian law school. There have been little or no content or competence-driven changes in our legal education curriculum that would expose students to an appreciation of how digital technologies impact the law and their future practice. This inertia in our curriculum is consistent with the manner in which our law schools have responded to other factors that have compelled curriculum reform elsewhere in the world. For example, law schools in Ghana have largely been insulated from the trends of interdisciplinary legal education, experiential learning, clinical legal education, and the challenge of globalization, which have forced many law schools worldwide to incorporate international, transnational, interdisciplinary, and comparative approaches in their curriculum, including also clinical legal education. Meanwhile, we continue to educate students so that they graduate with a pre-digital skills and a substantive understanding of the law and legal processes. To be sure, this is not entirely the fault of the legal academy. Existing regulations on legal education in Ghana impose an obligation on law schools to teach specific content to qualify for entry into the Ghana School of Law and subsequently to practice law. This prescribed degree content, which is largely derived from the analog era of the 1960s, when the Legal Profession Act was enacted, has not seen any significant revisions. For the most part, legal education in Ghana is about teaching legal rules embedded in cases and statutes. Happily, unlike in other jurisdictions, it is arguable that law schools in Ghana do not suffer from a crowded curriculum in which there is little scope for change. Accordingly, we have extensive room for innovation if provided with the requisite resources and the regulatory framework. In sum, we have scope to prepare our students for the digital future, a topic to which I will now turn my attention. Preparing students for the digital future. Our digital context invites us to re-evaluate our teaching practices and methods of delivering legal education, as well as the substantive knowledge and skills that students are expected to receive from our law schools. I argue in this lecture that there are several ways in which this can be achieved. Some of the current constraints on legal education reflect the existing attitude that all legal education should take place within the four corners of brick and mortar walls. However, should that continue to be the case, given the existing infrastructural challenges and constraints on staff, I argue that digital technology offers the attractive possibility of making legal education more efficient and effective in Ghana. At present, there is an array of legal learning management systems which are available, such as Blackboard, Moodle, Twin, and Canvas, all of which facilitate teaching and learning. The effective deployment of these learning management systems and the digital technologies that are embedded within them, combined with synchronous and asynchronous online teaching, or a blend of online and face-to-face instructions, could overcome some of the challenges to our physical education infrastructure. This will open up much-needed access to students. To be clear, I am not advocating for exclusively online undergraduate law degree programs. I think at this stage in our development, it is not suitable for us to consider administering undergraduate law programs online or moving the professional law course completely online. The skills training, skills development, professional development, and socialization components, which are indispensable to undergraduate law and professional law qualifications, are not easily attained online. We should, however, be amenable to delivering some of our undergraduate and professional law courses online, or at least certain aspects of them, using existing online learning management systems. there has been growing acceptance of online teaching as a means of delivering legal education. Law schools in many countries offer online credit-bearing courses, and in some law schools, whole graduate law degree programs can be undertaken online. In Ghana, it is my opinion that some lectures could be recorded and provided for students to listen to on learning management systems in advance of a class. Class time could then be devoted to problem solving, legal analysis, drafting exercises, small group discussions, moots, advocacy, and other collaborative exercises. This approach would give skills development a more prominent place than it currently occupies in our law schools, especially on the LLB program. In the professional law program, where skills development is apparently the paramount goal, this would enhance the realization of this goal. I argue that within our LLB and professional law programs, a limited reliance of this nature on online teaching could be appropriate at this stage of our development. However, the situation differs in case of Master of Laws degrees. Unlike undergraduate and professional law qualifications, postgraduate law degrees tend to be more knowledge-based and academically oriented. Postgraduate law degree programs are suitable for training the next generation of law academics and legal practitioners who wish to deepen their knowledge of specialized areas of law. Unfortunately, there is a significant shortage of individuals with postgraduate law degrees to teach in our law schools. It is regrettable that after 64 years of institutionalized legal education in Ghana, we cannot boast of strong postgraduate law degree programs in our universities. In our quest to train law students for legal practice, we appear to have lost sight of the need to train legal academics to teach our students in Ghana. We should be amenable to offering Master of Laws degrees either wholly or substantially online. I taught for several years on the University of Liverpool Laureate International University's online Master of Law degrees program. I also served as the Director of Online Studies between 2011 and 2017. The program had significant uptake of Ghanaian students and employed 2 lecturers who were based in Ghana. Graduate online law degree programs can be offered to the same degree of rigor as on-campus programs. Based on my experience in this field, it is my belief that our law schools should seriously consider this approach at the graduate level. Online programs of this type could, among other advantages, benefit from the teaching expertise of Ghanaian law professors in the diaspora, who for various reasons cannot physically locate to Ghana, but would be prepared to teach on these programs from their respective locations. As Professor Muna Ndulo observed, technology offers the possibility of global scholarly exchange that may occur with relative ease. Graduate students in Ghana could benefit from global scholarly exchanges of this kind through online teaching and learning. It should also be considered that most law students are digital natives, having been born and raised in the digital age. Therefore, they have every right to expect to be educated with curricula, teaching methods, and resources that reflect development in society and their ongoing experiences with digital technologies. Hence, the curriculum of our law schools should be reformed to incorporate digital competence and to accommodate the substantive impact of digitalization. Standalone courses in, for example, law and technology, law apps, cyber law, and electronic commerce could be offered as electives for interested students. Admittedly, A single standalone technology-based course on the curriculum is insufficient to help students fully develop technological competence for their future careers. However, in this era of digitalization, the absence of courses in these areas represent a significant shortfall in the curriculum. On other courses, lecturers need to carefully reflect on the content that they teach, thereby addressing areas that digitalization is likely to impact. We have a responsibility to offer students the opportunity to engage with a variety of digital media and legal applications. The aim of this approach is to engender an understanding of different digital tools and their implications for practitioners and society. In this regard, the ability to use existing digital research tools is especially important. Therefore, we must teach students digital research skills. Unfortunately, very few institutions subscribe to domestic and foreign proprietary legal research databases such as Dennis Law, Hein Online, LexisNexis, and Westlaw. The availability of these online legal research tools has been one of the most significant developments in the legal profession since the dawn of the digital age. At present, direct access to a well-stocked library of hard copy law reports, legislation, and academic treatises is no longer necessary to craft the best legal opinion or develop a robust piece of legal scholarship. Instead, legal opinions and submissions, as well as academic writings, can be produced using only online sources. Our inability to subscribe to domestic and foreign proprietary legal research databases should definitely not prevent us from consciously and concertedly taking advantage of online legal resources that are freely available. While such freely available resources might not be curated, indexed, or accessibly organized as the proprietary databases, they can nonetheless be very useful. For example, open education resources can broaden students' knowledge about the law. They can complement university teaching materials by providing a broader range of teaching options, including global perspectives from around the world. Similarly, the judgments of many courts in the Commonwealth are now freely available online and can provide comparative insights for issues on which there are gaps in Ghanaian law. Indeed, the Ghanaian courts are increasingly drawing upon persuasive authorities from outside the English courts, a testament to the relevance of a broader comparative law approach. Technologically focused clinical legal education is another means of preparing students for practice in the digital era. Clinical legal education involves students advising or representing real clients under supervision in a legal center or clinic, or via a practicum or internship scheme as part of a degree or professional qualification program. Digital technologies can be purposefully incorporated into clinical legal education programs. This would be in addition to traditional lawyering skills that are usually taught on these programs, namely communication skills, problem-solving skills, and professionalism. For example, the use of law practice management software in legal clinics, as opposed to manual record keeping, can give students an early introduction to actual practice. Researching clients' legal problems using online legal research tools and databases could likewise lay the foundation for similar engagement in future practice. Communicating with clients via email, Microsoft Teams, Zoom, and other video conferencing facilities simulate what happens in real-life scenarios. Furthermore, the use of social media to solicit prospective clients could offer important lessons for students to deploy similar measures in their future legal work. That is, assuming the restrictions on advertising of legal services is abolished as advocated in yesterday's lecture. In addition, through clinical work, students could be encouraged to find technological solutions to access to justice problems facing clients who come to the clinics on a day-to-day basis. Clinical legal education provides the practical training that is necessary for all law students to succeed in practice. Furthermore, it provides much-needed legal services to the poor, especially against the background of weak legal aid infrastructure as discussed in yesterday's lecture. The importance of clinical legal education has been recognized by Ghanaian scholars, including Frimpong, Mantiao, Mohe, Dino Usudapa, and Tufo. In its 2011 report, the Constitutional Review Commission called on law schools to instill a culture of legal aid in students. This is a culture that would be developed by working at legal clinics. Moreover, in a 2019 report, a task force recommended that the Legal Aid Commission encourage and support the establishment of legal aid centers in our law faculties across the country. Regrettably, compared to their counterparts in other parts of the world, law students in Ghana have limited or no experiential learning opportunities incorporated into their legal education programs, especially in the universities. The incorporation of experiential learning opportunities into the curriculum is not a requirement for accreditation. This is in sharp contrast to the situation in other African countries. For example, Wilson reports of legal clinics in South Africa, Zimbabwe, Botswana, Lesotho, Namibia, Zambia, Mozambique, Malawi, Kenya, Uganda, and a very long list. He describes Nigeria as the most aggressive adopter of clinical legal education in the last decade. The introduction of extensive practicums in law firms and other legal institutions as part of the Ghana School of Law's professional qualification program represents an important step towards making more room for skills development in legal education in Ghana. However, the effectiveness of extensive practicums in law firms and other legal institutions remains to be assessed. This lecture calls for the creation of legal clinics within our law schools and the removal of the regulatory barriers against the establishment and operation of such clinics. It is argued here that in developing legal clinics, our law schools would need to adopt a model that emphasizes both traditional lawyering skills and digital competence. Recognizing their potential contribution to providing legal services to the poor, it is important that legal clinics receive appropriate levels of funding to support their work. It is recommended that they are funded from the revenues generated by interest on lawyers' trust accounts, as discussed in yesterday's lecture. This is how legal clinics are funded in other countries. An important enhancement of students' learning is the quality and focus of research by faculty members. Research often informs teaching and hence the curriculum. Where faculty members actively research digitalization and the law, this can impact the content of their teaching and open up opportunities for selected student research assistants. Towards this end, this lecture argues that there should be a research center in at least one of our law schools dedicated to digitalization and the law. This center would be interdisciplinary to include other scholars from allied fields, for example, computer science, education, and engineering. The center would likewise need to engage with subjects that are not traditionally part of the jurist repertoire. One less frequently discussed issue regarding legal education and the digital context is the need to ensure that students of law understand the risk and benefit of digital participation for their future career paths and professional persona. It is now common for law students to participate in and be very active on social media. Students post all manner of information, pictures and videos, and exchange all sorts of ideas on social media networks. The advantage enjoyed by my generation and our predecessors is that our escapades at the university and at the Ghana School of Law are hopefully frozen and tucked away as mostly analog photos in albums. In contrast, for the digital natives of today, their adventures and rendezvous are captured in digital photos and videos, which are shared on social media, ready to be accessed through a Google search from anywhere in the world. Law students in Ghana should be trained to properly manage their professional persona on social media platforms, since this can affect their future career paths. The viability of incorporating digital competence into legal education in Ghana is contingent on the expertise of lecturers and professors who provide such education. Compared with a few decades ago, the current core of law lecturers and professors in Ghana are relatively young. However, this is no guarantee that they possess the relevant digital expertise. Developing this expertise will just not happen as an evident outcome of teaching skills and legal knowledge, and will not develop seamlessly without attention and effort to the preparation of professionals in legal education to overcome this gap. Accordingly, appropriate resources and professional training should be provided to our law lecturers and professors. Here, comparative lessons could be drawn from the government support for various personnel to develop oil and gas law expertise after we discovered oil in commercial quantities in Ghana. Additionally, collaboration with members of other faculties, such as computer science, could be useful for fostering digital competence among graduates of our law schools. However, a cultural shift would be required within the legal academy and professional community, a community that is notoriously impervious to change, in order for some of the above proposals to be realized. Aside from the above, there are institutional, organizational, and regulatory and financial hurdles that must be overcome to reorient legal education for the digital context in the manner which has been described in this lecture. For example, the high cost of digital technologies and learning systems can hinder their acceptance and integration into legal education. Indeed, most of the proposals in this lecture call for significant investment in digital teaching and learning technologies. This lecture therefore calls on the Ghana government to invest in digital teaching and learning technologies in our public law schools. It likewise calls on private institutions to similarly invest in such technologies. Again, funds for these investments could be partly provided through the interest on clients' accounts, which was discussed in yesterday's lecture. I'm very much interested in that thing. The Legal Profession Bill. The Legal Profession Bill aims to consolidate and amend the law relating to the legal profession. Accordingly, several provisions of the bill deal with legal education, both within the universities and at the Ghana School of Law. Most of the bill's provisions are beyond the scope of this lecture. For this lecture, the issue that I want to explore briefly is the extent to which the bill will help advance the leitmotif of the present lecture, namely the need to train law students for the digital world. At the outset, I would note that there are two modest provisions which are very useful. If effectively enforced, these would help prepare students for practice in the digital world. First, an applicant to the General Legal Council for recognition as a law faculty must state the subscription to online data sources for its law library. Second, the application must also indicate the availability of the faculty's internet services and the degree of reliability. The bill gives the General Legal Council the mandate to regulate and approve law faculties. It is expected to establish a recognition and quality assurance unit for this purpose. The General Legal Council is expected to determine the subjects in which those seeking to qualify as lawyers are to be examined, as well as the courses of instruction for students. The content-based model of regulating legal education in the bill is similar to the one which is adopted in the current Legal Profession Act 1960. I argue in this lecture that content-based regulation of legal education should be discarded in Ghana. Far from prescribing courses that law faculties must teach, it would be preferable for the General Legal Council to mandate a defined number of competencies or skills that students are required to demonstrate prior to admission to the Ghana School of Law. Law faculties would then be free to decide through innovative curriculum how to satisfy these competencies. Given the focus of this lecture, one of the competencies that should be prescribed is digital competence. The limitation of content-based regulation of legal education are too glaring to miss. It stifles innovation in the curriculum of law schools as they end up teaching the same courses, often referred to as core courses, with very few optional courses to students. Students also tend to focus on mastering the content of the courses, hoping to pass the closed book examination, only to forget the materials thereafter. Interestingly, another deficiency of content-based regulation is that once students graduate, they are often confronted with problems for which they cannot readily turn to any of their course materials to find answers. Indeed, as I often tell my students, if a senior lawyer asks you to research a legal problem and your first port of call is your law school lecture notes, you are most likely on the wrong track. What students apply most when they graduate, regardless of where they work, are the skills or competences that they acquired during legal education. I argue that should be the focus of the General Legal Council's prescription to law schools. A comparative model for such competence-based legal education is the Federation of Law Societies of Canada. The Federation has competency requirements that each student must meet for entry into a bar admission program in Canada. Law schools are largely free to determine which courses to teach to enable students acquire the prescribed competencies. Similarly, in the United Kingdom, where Ghana's legal education model is derived, the qualifying law degree for qualification as a solicitor in England and Wales has now been deregulated. The effect of this is that law schools are now free to make significant changes on how and what they teach. Indeed, one does not even need a law degree to sit for the solicitor's qualifying examination. the Solicitors Regulatory Authority in the UK, has ceased to participate in the regulation of legal education as learning. Instead, its focus is now on administering its own exams to assess the outcomes that students must demonstrate to gain admission. Madam Chairperson, I will now turn to my conclusion. Although tried and tested for 64 years, the approach to legal education in Ghana was designed for a former era, that is, the analog era. It has come under significant strain in recent time, being found wanting in many respects. Digitalization presents an additional challenge. Digitally mediated changes have occurred in many areas of life in Ghana. However, our approach to legal education has yet to fully engage with this reality. The time is ripe for a rethink. We must reimagine legal education in Ghana. Indeed, it is time for a commission study into the future of legal education in Ghana. This lecture calls for the first major sector-wide review of legal education and training in our country. All stakeholders, including our law schools, the bar, the bench, the General Legal Council, the National Accreditation Board, students, businesses, and the general public should be engaged in this process. We need a new vision of legal education in Ghana. However, before this major sector-wide review is concluded, there needs to be a pause in the establishment of new law faculties and departments within our university. In calling for a new vision for legal education in Ghana, I'm cognizant of the history of institutional change in legal education, which has often been slow and incremental at best. Innovation and experimentation are the exception rather than the norm when one envisages legal education. The transition from a legal education that is undergirded by the analog world to one that is anchored in the digital world will not happen overnight. However, this is not a reason for despair, nor an excuse not to capitulate. Our world has moved from an analog to a digital one, and legal education must follow. The discipline of law in Ghana needs to embrace the gradual digital turn of the law. Our law schools should pay attention to the profound changes that digitalization will bring to the country. We need to train our students in digital capabilities as well as in the traditional skills that are essential to legal and non-legal careers in a digitalized future. If our law students are to practice or work in a digitalized Ghana, and indeed the global economy, as lawyers, corporate executives, lecturers, government officials, to mention but a few, they cannot afford to lack the necessary skills to practice and work in such an environment. In the third and final lecture, I will turn my attention to consumer protection in the digital marketplace and work on digital labor platforms such as Uber, Bolt, and Jumia Food. Thank you.
Audience, you must admit Professor Pong has treated us to a very lucid exposition of legal education and professional competence in our digital system. Can we give him another round of applause, please? I cannot pretend to be able to summarize this wonderful presentation, but pick out a few salient points that came out. Basically, yesterday we heard about the first topic was access to justice in our digital world. And today is education and professional competencies. States that existing state of our legal education in Ghana are completely exposing the inadequacies and the various ways in which competencies can be approached, offering reflections on proposed legal professions, and basically in these components, the digital context, he touched on the context, current nature of our legal system in Ghana, where students are only trained for the law courts, and little is brought in about other alternatives. Very little curriculum reforms in our legal education, and the inertia he discussed in the Ghana education system. And then he touches on preparing students for the digital future and strongly advocating for clinical legal education and expertise, requirement of the expertise of lecturers and professions who can provide for this. Then he touched on the Legal Profession Bill 2021 and the need to prepare lawyers for the digital world. And I quote from him that the discipline of law in Ghana needs to embrace the gradual digital turn of the law, and that our law schools should pay attention to the profound changes that digitalization will bring to the country. Now, we thank you very much for this wonderful lecture. Another applause, please. Thank you, Prof. Opon.
Thank you very much, Chairperson, for those closing remarks and for chairing this evening's session. Applause, please, for our Chairperson. Thank you very much. And with that, we have come to the end of day 2 of this year's JB Danquah Lectures series. But before we leave, I have a few announcements. First, I'd like to acknowledge the schools represented here. Legon and Accra Technical Training College. A round of applause for the students, please. Thank you very much for staying with us. You were here with us yesterday, and you are back again today. I hope that you are paying keen attention. Some of you are going to be the future lawyers and law professors. And I hope you've taken in all that Professor Opong has said, because you are going to be part of the change that he is asking for. Thank you. Tomorrow will be the last in this year's JB Danquah Lectures series. And Professor Frimpong Opong will be back here to give his final lecture on the topic, Consumer Protection in the Digital Marketplace and Work on Digital Labor Platforms. It promises to be another very interesting and educative lecture. Please join us again tomorrow at the same time, 5:30 p.m., here at the auditorium and online. We have packed refreshments for you. Please speak up. We will not have a sitting. Please pick up a bag of food and drinks as you leave the auditorium. They will be right outside in the foyer. Thank you very much. If you could please stand while I escort the speaker out of the auditorium. Thank you.